SJC-12443, Angel Alvarez v. Commonwealth.
Good morning, or
Good
good
afternoon.
afternoon.
Now.
It did change
Before
while-
you begin, I will do a mea culpa with regard to Polk that I did misquote Hodge. Hodge says reasonable possibility. I went back, so you don't need to debate whether I was
Okay.
wrong. I was wrong as to what Hodge said.
Okay, well, thank you, Your Honor. May it please the court, David Rangovich again for Angel Alvarez. I'll resist the urge to reply to anything and just talk about the stay. This case is here on an abuse of discretion review from the single justice, and I want to see if I can convince Your Honors that this is exactly what happened here. It's a reasonable possibility of success on the merits. We just spent 30 minutes on the merits, so I'll set that aside. The second prong of the stay analysis is the security or safety risk prong, and I think you'd be, as I said in my brief, I think you'd be hard-pressed to find a defendant better than Mr. Alvarez in this regard. He has no other criminal record. He was on pretrial supervision for 2 years with $15,000 bond on the condition he have no contact with the alleged victim, and he perfectly complied. He never violated, he never defaulted. So he presents as no security risk. There's no factual basis, anything about Mr. Alvarez that would suggest that he's a security risk. And I think the Commonwealth's argument on this really boils down to the argument that just what he's charged with kind of overwhelms the two-pronged test.
He's more than charged now. He's been convicted and
what he's convicted of,
sentenced to 10 to 12, so
That's right.
that puts him, I mean, yes, when you're facing the possibility of trial and you think you may have a chance to win, you may be on your best behavior, but now you've already been convicted. Now your chances rest with the appeal. Does it not change the issue of flight?
Well, I think that falls into the category of arguments that prove too much, because I mean that's true of every person who's requesting a stay. And so what that
Only for a long sentence.
only for a long sentence, but there's no statute, there's no court rule that says that stays are reserved only for people who have short sentences. Actually, the block quotation from Levin that I cited at the end of my brief makes the point that it can abridge both a short sentence and a long sentence being denied a stay when the appeal is ultimately fruitful. So stays are not reserved only for extraordinary circumstances. They're reserved for people who meet the two-pronged test, and to the extent the charge of conviction does overwhelm, it will overwhelm in the pretrial conditions. Because of course a defendant, it will be a truly extraordinary case where a defendant can get out pending appeal when he was actually in pretrial. But there's no basis here for the extreme asymmetry between a $15,000 cash bond and no contact and confinement from which Mr. Alvarez can't get out. There's nothing about him. All the arguments that the Commonwealth, I think, could muster here are just about all people who get convicted of a serious crime.
Well, doesn't this go more toward wouldn't the argument go more toward whether there's a meritorious issue on appeal and what that means, whether it's a likelihood of success or just colorable issue?
Yeah, and I think the jurisprudence, as the Chief Justice, I think, said at the outset, the phrase is reasonable possibility of success on the merits, not some sort of likelihood or more likely than not type of analysis. So I would urge the court to...
But I think the point Justice Cipher is making is where there is arguably an inherent risk of flight because of the length of a sentence, don't you need a finding that says you're likely to prevail in order to get around prong two? I mean, yes, prong one has said historically reasonable possibility, but of course Hodge also, as you note, goes on to speak about reasonable likelihood. But do we not, maybe we should be looking at, maybe reasonable possibility gets you in the door, but you may need reasonable likelihood or substantial likelihood to win. Is that something we're permitted to consider, or is that off the table?
Well, I haven't seen any case that's really done that. That kind of ups, I think what you're talking about is upping prong one in the context of a serious or violent crime. I haven't seen, no case has done that. I mean, that would, I think, be within this court's purview to do that, but there's no rule that says that, there's no statute that says that. I don't think there's any basis for the court to be doing that. I mean, I think whatever that heightened standard would be is certainly met in this case. I think it's it would suggest that it's largely met just by the fact that direct appellate review is granted. I don't think this court, unless you can tell me if I'm wrong, but I don't think this court grants direct appellate review just to kind of slam the ball in the defendant's face in a frivolous case. I think it has to be a serious case, and this case has the unique situation where we not only have the issue that was granted direct appellate review on, but we have the closing argument issue, which, as I said just a moment ago, is I think the strongest issue in the case, and I think the Bowden issue is also particularly strong. So whatever that heightened standard might be, if this court wanted to establish it, I think is amply met on these facts. And if the court has no further questions, I'll submit.
All right, thank you.
Thank you very much.
Nathaniel Bodman again. And I just want to say that this has been, this motion was denied by 2 judges now. It was denied in the Superior Court by Judge Wren. It was denied by Justice Kafker acting as a single justice. I believe there's been no showing that there was an abuse of discretion by either one of those judges. And if there are no questions, I will rest on the opposition that was provided.
Well, let me just sort of play this out in terms of the standard, because we're sort of in a weird position.
Yep.
And put aside this case, because I don't mean to suggest, but let us imagine a case in which we basically go back to Sample and say the defense is going to win. But the single justice didn't know that. Do we hold him, even though we know or pretty sure that the outcome is going to be a reversal?
If there was a case where the court,
I'm not suggesting that that's how this plays. I don't know how this case is going to play out. So this is purely a theoretical. So don't take any meaning from the question, except that could happen.
Yep.
In a case. What do we do?
If the court was, what I was going to say was, I think if the court was going to overturn a decision, and they felt, or it was a possibility they were going to overturn a conviction because the appeal had a reasonable likelihood of succeeding, I could see the court granting the motion to stay. Yes.
Even though the single justice did not abuse his or her discretion, because the single justice wouldn't have known that.
I would suggest, yes, there perhaps could be a scenario where that would occur. And I would just rest on the arguments in my brief where,
Right.
in this case.
I know you
yeah.
said this is not that case.
Okay.
I understand.
Yep, I understand.
Okay.
Thank you very much.
Court will rise.